Yes, Miss Yasika, please go ahead. Yasika?
Yes, sir. Yes, sir.
Yes, please.
Good morning, everyone. I welcome you all on behalf of Vidya Vijay Foundation. This session aims to enlighten us all on recovery of dues through summary suits under Order 37, Code of Civil Procedure 1908. It takes immense pleasure for me to call Dr. Nityanand Singh, who is a member of Honorable Supreme Court of India and fellow member of Institute of Company Secretary of India. He has secured doctorate in law. Mr. Singh is an advocate by profession and practicing at Honorable Supreme Court of India. He has extensive experience of more than 20 years in litigations. Mr. Singh is a partner and founder of an international law firm named the Lux Legal. Lux Legal has been operating as a corporate law firm in retail concept and currently handling litigation matters in more than 500 districts in India and abroad. Mr. Singh is also running an NGO with the name and style Vidya Vijay Foundation and serving the poor and marginalized communities in India. Mr. Singh is also a member of Honorable Supreme Court of India and fellow member of Institute of Company Secretary of India. Social and Living Standard. The name Vidya and Vijay cute is the name of his mother, Mrs. Vidyadhari Devi, and father, Dr. Vijay Narayan Singh. Mr. Singh is a visiting faculty of IIM, ICSI, ICAI, and various other law colleges and business schools in India. Mr. Singh is also socially and politically active and contested the election of Legislative Assembly at Delhi twice. Now, I would like to call upon Dr. Nityanand Singh to proceed with this session and embark all of us upon this topic with his knowledge and wisdom.
Thanks, Miss Yasika, for such a wonderful introductions. Good morning to all of you learned friends. Today we are going to have a session on the summary procedure, how the amount can be recovered through summary procedures. Then we will, first of all, we will tell you the entire act, what is the act and what is the provisions of the law under Order 37 CPC. This is the theoretical aspect. Within half an hour, we will cover the theoretical aspect, and another half an hour, you will cover the practical aspect. Means how you can file an applications, suit, and how to leave to defend, I will find, and thereafter, how to tendering the appearance, and how the court pass an order. All those details we will cover through the practical aspect after half an hour. I would like to request to all of learned friends, if it is possible, to switch on your cameras, and certainly once you are agree with us, then also type in the chat box yes, no, and whatever your comments would be. So with all your permissions, may I go ahead? If it is yes, then type out in the chat box yes. Thank you. First of all, we will cover what is the provisions under Order 37 CPC. Order 37 CPC. Recovery of dues. Recovery of dues through summary suits under Order 37 of the Code of Civil Procedure 1908. What is the summary suit? First of all, I would like to explain what is the summary suit. The summary suit refers to the type of the legal proceedings under the Code of the Civil Procedure. The summary suits are intended to provide a speedy and relatively simple means of resolving certain types of the civil disputes without the need for a full trial. This is the one of the advantage of the summary suit, that we cannot go for the entire trial, like as a leading of the evidence and cross examinations. So the full trial, we can certainly recover the amount within a certain period of the time. Otherwise, you can go for the summary trials that takes time, at least 3 to 4 years. But here in the summary suit, it can be decided within a period of the 6 months. So this is the advantage of the summary suit. And where which order of the CPC relates to the summary suit. The provisions of Order 37 of the CPC deals with the summary suits. Order 37 Rule 1 provides classes of the suits where it can be instituted. Order 37 Rule 1 says where you can file a suit. And Order 37 Rule 1 Sub-Rule 2 says summary suits applies to the following class of the suits, namely. This is very important, under which provisions we can file a summary suit and when we can file a summary suit. Summary suits can be filed under these circumstances only. Suits upon bills of exchange, hundis, and promissory notes. If any bills of exchange, like as a check has been issued, hundis are promissory notes. Promissory notes means there are the certain written notes that yes, I am liable to pay certain amount. Then Order 37 will be applicable. Another thing, suits in which the plaintiff seeks only to recover a debt or liquidated demand in money payable by defendant with or without interest. Means there should be certain debt or liquidated demand. Liquidated demand means a claim for a specific sum of money payable under a contract express or implied, not being a nature of the penalty. Means there should be some contract between the parties, and whatever the amount has to be mentioned, that amount has to be the specific amount. Because Order 37 is applicable only when there is a the specific amount, means confirmed debt. Debt should be the confirmed. Once you have received certain amount and you have given in the writing that yes, I am liable to pay certain amount, then certainly it covers under Order 37. On a written contract, the provisions is given on a written contract. If there is a contract between the parties, and in that contract it is clearly and specifically mentioned that yes, I am taking certain amount from you and certainly I will pay certain amount at certain period of time, then it covers under Order 37. On an enactment where the sum sought to be recovered is a fixed sum of money or in the nature of the debt other than the penalty. There should be some enactment where there is a fixed sum of money. There are the certain amount that is a fixed, that yes, you have to pay certain amount, then it is covered under Order 37. But it should be not in the form of the penalty. On a guarantee where the claim against the principal is in respect of the debt or liquidated demand, there should be some guarantee that yes, I will pay certain amount. Suit for the recovery of the receivable instituted by any assignee or of a receivable. Then Order 37 Rule 1 Sub-Rule 2 says when we can file the suit under Order 37 CPC. If it is clear to all, please type in the chat box, yes, clear. Thank you. Now, where can summary suits be filed? Which court can entertain such a summary suit? A plaintiff can file a summary suit in the court that has jurisdictions over the area where the cause of action arises. This is the very important things we have to understand where you can file a suit, because jurisdiction is a very important issue once you are filing a suit before the court. Once you are not filing the suit before the proper jurisdictions, then it is a very embarrassing positions that you will come to know your case will be dismissed only on the ground of the jurisdictions. So you should be very cautious about it, that once you are filing the suit, you have to be very cautious about the jurisdictions issue. Where you are filing the suit, you have to analyze all the aspects where you can file a suit. Plaintiff can file a summary suit in the court that has jurisdictions over the area where the cause of action arises, or where the defendant resides or carry on the business. In other words, the suit can be filed in the court that has the territorial jurisdictions over the matter. Means there are the 2-3 grounds where you can file a suit. First of all, you have to look into where the cause of action arises. Cause of action arises means where there is an agreement executed between the parties. Suppose the parties are residing somewhere outside of the Delhi, but the agreement has been executed at particular place in Delhi, then you can invoke the jurisdictions of that particular place in the Delhi. If the agreement has been executed in the Gurgaon, then you have to file a suit in the Gurgaon because cause of action arises at that particular place, or where the dependent resides or carry on the business. If the dependents carry on their business in Delhi, then you can file in Delhi. If it is carry on the business in somewhere else, then you have to file the suit in somewhere else. So there are the 2-3 cause of actions. We have to look into whether any one of the cause of action arises in that particular place. Then you can file a suit on that particular jurisdictions of the court. Summary suits can be instituted in the courts of the small causes, city civil courts, high courts, and any courts notified by the high court. In Delhi, once you are talking about the Delhi, there are the certain powers are vested with the civil judges of the pecuniary jurisdictions, and that pecuniary jurisdictions you have to file a summary suit with that civil judge. If it is more than that pecuniary jurisdictions, there are the certain limits of the pecuniary jurisdictions. More than that limit, then you have to file before the ADJ or DJ. And if it is more than that pecuniary jurisdiction, then you have to directly go to the High Court. The jurisdictions of the district court up to 2 crores, and more than 2 crores, you have to go to the High Court. Original jurisdictions. Procedure for summary suits. Once it is clear to all of you, then who is the competent jurisdictions, who is the competent court to file a summary suit, and which type of the suits can be filed under Order 37 CPC. If it is clear to all of you, please type out in the chat box yes. Otherwise, you can also give a comment in the chat box. Certainly, we'll go through and certainly answer that. Procedure for the, if it is clear, then we will proceed further. Procedure for summary suit. How the summary suit can be instituted before the court and how it will go further. Whenever we file a summary suit, we need to clearly mention that we have filed the suit under Order 37 of the CPC 1908, and that no relief which does not fall within the ambit of this rule has been claimed in the plaintiff. Once you are filing the suit, then you have to be clearly and conspicuously mention below the case number that this suit is under Order 37 of the Code of Civil Procedure 1908. Once you are not writing this word, then your case is not maintainable under Order 37 CPC. You have to be very cautious, very clear. And at the last, at the bottom of the suit, I will also show the practical examples, but this is the theoretical, then we will only theoretical, then we will cover the practical portion. And the last of the suit that you have to cover, that no relief which doesn't fall within the ambit of this rule has been claimed in the plaintiff. These 2 lines have to be necessarily added as per the law. After institution of the summary suit, the Honorable High Court may please, Honorable Court may please to issue summons to the defendant in the appropriate form. Once the suit is instituted before the court and court finds it correct, means once you are filing an agreement, agreement has to be filed in original. Once you are filing the duplicate, means photocopy of the agreement, then Order 37 summons will not be issued by the court, and court will ask you, yes, please deposit the original document. And once you will deposit the original document, then and only then the court will issue summons. This is also a very important point. Then once you are filing the Order 37 summary suits, then you have to file the original document, whatever the agreement. If it is on the basis of the check, then you have to file the original checks. And once it is filed on the basis of the promissory note or hundi, then you have to file the original one. This is also a very important point to be noted. After institution of the suit, the Honorable Court may please to issue summons to the defendant in the appropriate form, form number 4. I will show the form. And plaintiff has to file process fee. And once the process fee will be filed, then the process server agency will serve the summons to the defendant along with the complete paper book of the state. Once the summons has been issued by the Honorable Court, then the plaintiff has to file the process fee along with all the paper book to the serving agency. And once the serving agency receives the entire set of the document, then the summons will be prepared, and then that summons will be served to the defendant. Now, this is a very interesting topic of the summary procedures, and there are the certain provisions is something different from the normal recovery procedure. There should be, you have to be very, very cautious. Once you are receiving the summons from the court, then it is a defendant is duty bound to tendering their appearance before the honorable court within 10 days. This days is very important. Within 10 days of receiving of summons, the defendant has to enter an appearance and serve the copy of appearance to the plaintiff and also to the court. Once you have received the summons from the honorable court, then within 10 days from the receiving of the summons, this 10 days is very important. Within 10 days from the date of receiving of the summons, defendant has to enter the appearance and apprised to the plaintiff that yes, we have received the summons and we are entering appearance before the court, as well as I also intimating to you. And once they are entering into the appearance before the court, they will also apprise to the court of all their addresses to serve the judgment for summons. If the defendant does not enter an appearance within 10 days from the date of the receiving of summons, then the plaintiff shall be entitled to a decree for any sum not exceeding the sum mentioned in the summons, together with interest and cost. Once the 10 days is over, the decree will be against you. Once you are the defendant, you should be very cautious of the 10 days. Once the 10 days is over, the decree will be passed against you. If the defendant enters an appearance and once within the 10 days you have entering the appearance and enter your appearance, then the plaintiff shall file summons for the judgment before the honorable court, and the honorable court may please to issue summons for the judgment in the prescribed form to be served on the defendant. Once you have been tendering your appearance before the court and also served to the plaintiff, then the plaintiff will file the summons for the judgment before the honorable court, and taking into considerations of that summons for the judgment, the honorable court again will issue summons for the judgment to the defendant. And again, you have to be very cautious about the days. This is the summary procedure. Then you have to be very cautious about the days. Within 10 days of receiving of summons for the judgment, the defendant has to apply for leave to defend of the suit. Once you are receiving the summons for the judgment, then within 10 days from the receiving of summons of the judgment, you have to apply to the court and file leave to defend. Once you will not file leave to defend within 10 days from the receiving for the summons of the judgment, then decree will be passed against you or against the defendant. The defendant does not file leave to defend before the honorable court within 10 days from the date of the receiving of summons for the judgment, then the plaintiff shall be entitled to a decree for any sum not exceeding the sum mentioned in the summons, together with the interest and cost. So these 10 days time after receiving the summons and 10 days time to file the leave to defend after receiving the judgment for summons is very important, very, very important. You cannot ignore that. Yes, on the next date of normally what happened, the person received the notice. They normally think once before the next date of hearing, on the next date of a hearing, you will go to the court and apprise to the court, yes, I am coming here and I will file a kalatnama. No, not in the summary procedure. This is not a normal civil recovery procedure. You have to be very cautious. 10 days time is a very, very important. Leave to, once you have filed the leave to defend, then it depends that whether your leave to defend have a tribal issue or not. Once the leave to defend doesn't have a tribal issue, then your leave to defend will be dismissed and decree will be issued to the plaintiff. But once there is a certain tribal issue, then your leave to defend may be granted, and it may be granted unconditionally or may be granted with certain conditions. Once it is granted unconditionally, then it is converted into the normal recovery suit. Then you will file the WS and all those procedures you have to follow. And once it is granted conditionally, then you have to deposit certain amount with the court. And once you have not complied that order, those conditions, then again the decree will be passed against the defendant and in favor of the plaintiff. If the defendant has not applied for leave to defend, or if such an application has been made and refused, even though you have filed the leave to defend, but your leave to defend has not been allowed and it is refused, then the plaintiff becomes entitled for the judgment forthwith. If the conditions on which leave was granted are not complied with by the defendant, then also the plaintiff becomes entitled to judgment forthwith. Whatever the condition, it may be allowed conditionally, it may be allowed unconditionally. if it is allowed with leave to defend has been allowed with condition, then you have to comply with all those conditions. However, the court or judge may, for sufficient cause shown by the defendant, excuse the delay of defendant in entering an appearance or in applying for leave to defend the suit. Yes, there are the certain provisions in the Order 37 CPC that yes, you can also file tender your appearance after 10 days, subject to condition that you have to move an application for the condonation of delay. And condonation of delay, it is discretionary power of the Honorable Court that whether the condonation of delay may allowed or may not be allowed. And it may be allowed subject to cost, or it may not be allowed, may be dismissed. Once your condonation of delay is dismissed, suit is decreed in favor of the plaintiff and against the defendant. Then this provision is a very, very important. You have to keep in mind. If leave to defend is granted by the Honorable Court, then the summary suit converted into the normal recovery suit, and defendant will be provided an opportunity to file their written statement within the prescribed statutory period of the time. Once leave to defend has been granted unconditionally, then the defendant has an opportunity to file the written statement, whatever the time, and thereafter the suit will be the normal recovery suit. There is a difference between the normal recovery suit and there is a difference between the summary procedures. Leave to defend is not granted, then it is decreed. This is a very good procedure to adopt for the persons who want to recover the amount from anyone, subject to condition that there should be the confirmed debt, like as a bill of exchange, hundi, promissory note. There should be some agreement which clearly depicts that yes, there are the certain amounts which due and payable by that person. So Order 37 is applicable only in that conditions, not in the all those conditions. Then Order 37, Rule 1, Sub Rule 2 is very important. Now, what decree may be expected in the summary suits? The plaintiff entitled to the decree for sum not surpassing the amount mentioned in the plaint, including interest and cost, in case the defendant doesn't present himself before the court or does not make an application for leave to defend or challenge the amount so claimed, or in case where the defendant has made an application for leave to defend, but the same has been dismissed by the court. Whatever the amount you have claimed, once you are filing the Order 37 suit, then you have to be very cautious that whatever the amount is due, and that is the confirmed date, you should only claim that amount. Suppose I have given in the writing to anyone that I will pay 1 lakh rupees. And once at the time of the filing of the suit, you are writing that 1,01,000 rupees or 1 lakh rupees one, then it is not covered under Order 37. Whatever the confirmed date, that only covers under the Order 37. Even the 1 rupee is more than the confirmed date, then it is not covered under Order 37, and court will say no, it is not covered under Order 37, and you should go for the normal recovery suit. So you should be very cautious about it. If it is my all learned friend is getting all my points, please type out in the chat box yes. Thank you. What is the, then we have to also keep in the mind what is the limitation period. What is the limitation period to file a summary suit? The limitation period to file a summary suit in India is governed by the Indian Limitation Act 1963. As per the Act, the limitation period for filing a summary suit is 3 years from the date of the cause of action arises. When the cause of action arises, the limitation period is 3 years from the date of cause of action arises. Then you have to be also very cautious about that. Once you want to recover any amount from anyone, then it has to be filed within 3 years from the cause of action arises, months when your amount is due. Now, probably it is clear to all of you. If it is clear, please type out in chat box yes. Thank you. And then we will understand what is the difference between the summary procedure and ordinary suit. Point of difference, provisions. Order 37 of the CPC provides for the summary litigations. Means there are the certain provisions within 10 days, 2 times, and leave to defend is granted. Then it is become normal recovery suit. If it is not granted, decree has been passed. Ordinary suit is registered under Section 26, Order 6, Rule 1 of the CPC. Ordinary suit is something different. Once we receive the summons, then on the next date of hearing, when the date will fix, you can go and file your kalatnama and then proceed further, but not in the order 37. In a summary suit, the defendant has 10 days to prove his case. 10 days only has been granted to tender your appearance. The time limit for submitting a written statement in an ordinary suit is 30 days. And to leave to defend has to be filed within 10 days. And here in the ordinary civil suit, you can file the written statement within 30 days. It may be extended up to 90 days. But here, there is no extension beyond 10 days. This is the difference. Summary suits can only be brought in two types of the cases. Here, the summary suits can be only confined to the certain types of the cases. First, suit based on the bills of exchange, hundi, promissory notes, and to recover a debt, liquidated demand payable in money by the defendant on the written contract or on a guarantee. There should be some confirmed debt. There should be some conformity. Yes, this amount is confirmed. Yes, he has to pay. Then only you can go for the order 37. But in the ordinary civil suit, you can, even though their amount is not confirmed, then you can file a recovery suit. Ordinary suits can be brought for any reason and are not confined to any specific type of the suits. The defendant doesn't have any right. Defendant doesn't have any right to defend the summary suit unless the court gives conditional or unconditional authorization to the defendant. Leave to defend is granted. It may be subject to conditional or unconditional. But in ordinary litigation, the defendant has the right to defend the claim and no leave to defend is required. Leave to defend is not required. He has every right to defend his case. But in the order 37 says it is not his right. Once the leave to defend is granted, then it is his right. Once not granted, then decree is passed against him. Ex parte decree can be issued to the plaintiff in summary proceedings if the defendant fails to appear in the court or refuses to defend the matter. Once he is not tendering their appearance within 10 days, then it will be proceeded ex parte, if it is not supported by the condonation of delay applications. The ordinary civil suit, several summons are sent to the defendant when an ex parte decree is issued. Before proceeding ex parte, there are the certain other 2 times, 3 times summons has been served. Unless and until it is served, no ex parte decree has been passed. Therefore, I have covered all the theoretical aspect. So, if any of my learned friends have any questions on this issue, certainly I will answer those questions and proceed further.
गुड मॉर्निंग नित्यानंद जी।
गुड मॉर्निंग सर, प्लीज।
कैसे हैं सर? सर मेरा इसमें क्वेश्चन ये है कि सपोज आई हैव डिग्री इन फेवर ऑफ कंप्लेंट फ्रॉम द कंज्यूमर कोर्ट फॉर एन अमाउंट, सर्टेन अमाउंट,
जी जी जी,
and for the recovery proceeding of that order, for the purpose of executing that order, can I go to the civil court under order 37?
yes, you can go, because this is a decree passed by the consumer court. Yes, you can go under order 37 because it is confirmed, and you can also file an execution before the consumer court. This is also remedy available to you.
Okay. That means there are 2 remedies available. Either you can go to the civil court or to the consumer court directly.
Yes, sir.
Okay. Thank you, sir. Thank you so much.
Is any other my learned friends? Then we will proceed further and touching upon the practical aspects. How you can file a suit under order 37 CPC. What you have to keep in mind in the once you are filing the suit under order 37, I will show the templates, formats, how you can file a suit in the court of district judge, suit number so and so. This I was discussing with this, that suit under order 37 of the Code of Civil Procedure 1908. This has to be clearly mentioned once you are filing the suit under order 37 CPC. This is very important. Once you are missing this line, then your suit is not maintainable under order 37 CPC. So keep in mind always. once you will prepare the index, and we will cover the index later on because what are the contents are, then we will prepare the index. This is the memo of party, and memo of party is very important because this decides the jurisdictions where it can be filed. Where you are filing the suit, it decides the jurisdictions. It may be on the basis of the cause of action arises, or on the basis of the persons resides or carry on the business, on the basis of the dependents resides or carry on the business. Once the dependents resides or carry on the business in Delhi, then you can file a case in Delhi. Otherwise, if there is an agreement, even though they are not residing in Delhi, carrying the business in somewhere else, but the agreement is executed in Delhi, cause of action, then the cause of action arises in Delhi, then you can file a suit before the Honorable Court at Delhi. There are the 2-3 options are available to you to file a case before the court. First, that the cause of action arises, is their agreement has been executed on that particular case. Second one, the dependents resides, and third one, the dependent carry on their business. If the address of the dependent is in Delhi, then you can file a summary suit under Order 37 in Delhi. These are very important points because once you will find that you have that particular court doesn't have a jurisdiction, then your case may be dismissed on this ground alone. Then once you are filing the suit, then you have to mention clearly suit for recovery of rupees so and so along with pending right and future interest under the provision of Order 37 of the Civil Procedure Code. This is important that once you are filing the recovery suit, then you have to clearly and conclusively mention that this suit is under Order 37 CPC. Value of the suit. What should be the value of the suit? You have to mention clearly. It may be whatever the amount is, and what is the court fee. As per the value of the suit, you have to pay the court fee. And once you have mentioned this court fee, then you have to mention what the plaintiff is doing, and thereafter you have to mention what the defendant is doing. And thereafter, brief facts of the case, means what happened. Means suppose if you have taken certain amounts, you have given certain amounts, then he has promised to pay that amount in the within so and so period of time. But once he has served the legal notice, even though he has not paid the amount, these all are the factual matters come into this brief facts of the case. And another para in the last, you have to mention that yes, this suit is within the period of limitations. This is a very important point also, because you have to mention that yes, this is within the period of limitations. Once your suit is not within the period of limitations, then you have to move an application for condonation of delay. And Honorable Court has jurisdictions to entertain the suit because the part of cause of action arises and so and so, and all those details you have mentioned that cause of action arises or resides in that particular place or carry on the business on that particular place. Therefore, this Honorable Court has jurisdiction to entertain such a complaint. This is a jurisdiction issue. And another point, that value of this suit for the purpose of the court fee and jurisdictions, these all are the points, are the very relevant point, and you have to mention. It is mandatory, not optional. These points have to be mentioned in the suit, then your suit is maintainable. Otherwise, your suit may be dismissed on this ground alone. The value of this suit for the purpose of the court fee and jurisdiction is so and so, and you have paid the court fee. Once you are not paid the proper court fee, then the court will not issue summons to the defendant. So you should be also very cautious that once you are filing the suit, then you have to pay the court fee accordingly. Not a single rupee is less than what is the appropriate fee. Once even the single rupee is less than the whatever the court fee, then the court will not issue summons to the defendant. You should be very clear about it. And this one is the last para. Whatever we have in the theoretical aspects we have discussed, that you have to mention in the Order 37 suit that this suit is filed under Order 37 of the Code of Civil Procedure, and no relief has been claimed which doesn't fall within the ambit of Order 37. This line is mandatorily you have to mention in Order 37 suit. This is the requirement of the law. Once you are not mentioning this line, then your suits will not be entertained by the Honorable Court. So this is very important. Then whatever the prayer would be, that you can ask for the court that yes, certain amounts you want to recover along with the interest, penalty and future interest and cost, whatever the cost. Once you are adding this cost, suppose once you are adding the cost of rupees 1 lakh and you want to recover suppose 10 lakhs, then you have to pay the court fee on 11 lakhs rupees. It should be also very clear in your mind that once you are asking for the recovery of the suit rupees 10 lakhs, not only you have to pay the court fee on only 10 lakhs. When you are asking the cost of the suit of rupees 1 lakh, then 1 lakh has to be added in that 10 lakh, then it becomes total 11 lakh. Then you have to pay the court fee up on rupees 11 lakhs. So this should be very clear in your mind. Pass such other further orders as the honorable court may deem fit. This is the prayer clause, and below the prayer clause, verification clause. Verification clause is also mandatory in nature. It has to be mentioned. Once you are not verified the plaint, then your plaint is liable to be dismissed on this ground alone. Therefore, this should be the very clearly mentioned verification. Yes, verified the content so and so, and para number so and so on the plaint are true to my knowledge derived from the records of the plaintiff maintained by the ordinary course of business. Para number so and so, true information received and believed to be last whereas the humble prayer to the honorable court. And it has to be properly signed by the plaintiff and through their advocates as well. So here is the plaintiff and here is the plaintiff. It has to be properly signed. Once it is not signed, then your suit is not maintainable. And it has to be properly supported by an affidavit. You have to also support your claim along with the affidavit, your name, father name, age. Once you are not also mentioning the age, that once you are filing before the honorable court, high court, then it is under objections. Then everything is very important to mention clearly: name, father name, and age, and your address. And you have to mention that yes, I am authorized signatory of the plaintiff and conversant with the facts and circumstances of the case. And accompanying suit under order 37 has been drafted by counsel under my instructions and contains true and correct. This is all, and you have to sign here on the deponent and deponent. Once you are not signing on the deponent, this suit is not maintainable. So this is all about the order 37 suit, how you can file a suit before the court. If it is clear to all of you, please type out in the chat box yes. If any doubt, also type on the chat box. Certainly I will answer to those doubts. Now we'll move further. Once the order 37 suit has been filed, then the court will issue the summons. I will show how the summons will be issued and what is written in the summons, because I am touching the practical aspects. This is the summons. Form number 4, summons in the summary suit. 2, name, description, and place of the residence. Whereas Mr. So-and-so has instituted, it is the name of the plaintiff, Mr. So-and-so has instituted a suit against you under order 37 of the Code of Civil Procedure 19 for rupees so-and-so, and interest you are hereby summoned to cause and appear to be entered into within a 10 days. This is very important. Here it is very clearly written that you have to tender your appearance within 10 days from the service thereof. In default thereof, plaintiff will be entitled after the expiration of the said period of 10 days to obtain a degree for any sum not exceeding the sum rupees so-and-so and the sum of rupees so-and-so for cost, together with such interest, if any, as the court may order. Whatever I have described in the theoretical portions, that once you are not tendering your appearance within 10 days, then decree will be passed against the defendant. It is also very clearly mentioned in the summons. When we will receive the summons, it is also very clearly mentioned that yes, you have to tender your appearance within 10 days. Here it is very clearly mentioned. So you should be very cautious about it. Now, once the summons suit has been filed, summon has been issued, how to tender the appearance, I will show. How to tender an appearance. This is the format of the tendering of the appearance. The court of district judge and whatever the court may be, civil judge, district judge, whatever, suit number so and so, order 37 of summary procedure so and so, matter under so and so, you have to tender an appearance like that, tendering of appearance on behalf of the dependent. You have to write like this, and then that the above named dependent has received the summons on suit so and so, directing the dependent to enter into the appearance within a period of 10 days. Means once you have received the summons, you have to clearly mention here that yes, on that particular day, I have received the summons. Only because of that, the court will look into whether it is within the 10 days or not. The defendant hereby tenders his appearance through counsel so and so as per the directions of the Honorable Court. And defendant has also notified the plaintiff regarding entering his appearance before the Honorable Court on so and so. The address of the defendant for the purpose of serving the notices of summons is here given. You have to also given your address, on which address you want the summons for the judgment. So this address has to be also clearly mentioned once you are appearing, tendering appearance. It is address of the defendant, and this has to be properly signed and supported by wakalatnama. We have to also, once you are not appearing in the person, then it has to be supported by the wakalatnama. So this is the format of the tendering and appearance. Now, once you have tendered appearance, then the court will ask that yes, Mr. Plaintiff, you have to file summons for the judgment. Then you will look into how the summons for the judgment can be filed. Yes, this is the format, templates for filing summons for the judgment. Application under order 37, rule 3, sub rule 4 of the Code of Civil Procedure 1908 for issuing summons of the judgment to the defendant as defendant has entered appearance before this honorable court. This has to be right very clearly. Yes, the defendant has entered their appearance, therefore you are filing the summons for the judgment. And this summons for the judgment, the plaintiff has filed recovery to defendant so and so. It has to mention that yes, this is he is tendering their appearance, and defendant is still paid to suit to the amount. He has not paid certain amount, whatever the amount you want to recover. In cause of action, filing the suit in favor of the plaintiff and against the defendant on various dates when the plaintiff so and so, cause of action you have to be mentioned. And defendant has no defense. This line has to be added in this summons for the judgment, that defendant has no defense in his suit as the amount claimed has not been paid by the defendant to the plaintiff. So, and you will have a prayer that summons for the judgment, defendant issue summons for the judgment to the defendant in terms of order so and so, and thereafter an affidavit in support. You have to clearly mention all those contents of your suit, whatever the suit contents of the suit, you have to mention here in the form of the affidavit. Once you have filed this application for the summons of the judgment, then the court will issue against the summons. Court will issue again summons for the judgment, and that summons, like whatever I have shown you, that summons in the form of the 4A, summons for the judgment in the summary suit. Again, summons for the judgment will be issued, and it has been also clearly mentioned that within 10 days you have to file the leave to defend. Leave to defend has to be filed within 10 days, and we will consider, once you are appearing on behalf of the defendant, how to file leave to defend. This is the format to file a leave to defend, and once you are filing the leave to defend, it has to be very clear in your mind that there should be some tribal issues are involved. You have to write, and you have to prove to the court, yes, my lord, this case cannot be summarily decided because there are the certain tribal issues, and those issues can be only decided after being a full-fledged child. Once you are able to prove this, that yes, this has to be proved through the full-fledged trial, then the leave to defend will be granted to the unconditionally, and thereafter, once the leave to defend has been granted unconditionally, thereafter the entire should be converted into the normal recovery procedure, and that will take some time. Once there is no tribal issue, and so you are not able to prove that there are the certain tribal issue, then your suit, then the defendant doesn't have the right and leave to defend of the defendant has been dismissed and suit will be decreed in favor of the plaintiff. Then it has to be very clear in your mind that there should be some tribal issues and you have to prove yourself. Application under order 37, rule 3, sub rule 5. Rule 3, sub rule 4, you have to file the judgment for the summons, and rule 3, sub rule 5, you have to file leave to defend. Depending on already, you have written that yes, you have already put your appearances. Leave to defend on the suit ground is written in affidavit annexed in this application. Kindly read in part and parcel. Moving this application within that, it may be the delay, but it is within the 10 days from the date of the receiving of the summons for the judgment. If there is a delay, then you have to clearly mention that there is a delay. Then you have to move an application for condonation of delay. Affidavit along with the application. This para is important. Affidavit along with the application discloses such facts which are sufficient to entitle the defendant number 1 to defend the opposite suit. And the affidavit of defendant number also discloses the tribal issue. This word is very important. Tribal issues. Once you are able to prove that there are the certain tribal issues and it can be only decided through trial, then leave to defend has been granted unconditionally. Otherwise, it may be granted conditionally. Otherwise, it may be dismissed, which can only be adjudicated by way of evidence that the defendant number 1 is entitled to the unconditional leave to defend of the aforesaid case. This line is very important. There are certain tribal issues and unconditional leave may be granted. Thereafter, whatever the defense you want to take, you have to take the defense only through affidavit. This is the affidavit that yes, how it can be proved yourself that you are doing some business and there are the certain tribal issues and you have taken certain defense that you have issued check, not check, or suppose it is a case of the checks. Then you have to say that yes, this check was the only security check or that check has not been issued against any liability. And whatever you want to take a defense, once there is an agreement, promissory notes, once it is a promissory notes you have written, given by in the writing, then you can take a defense that yes, this is not given by me. My signature is the forged signature. This is not the original signatures. All those defense can be taken, even though it is the original signatures, but you can take a defense in any way because you have to defend yourself. Yes, there are the certain, and you are able to prove that yes, I am not liable to pay, or once you have paid certain amount through cash or any other mode, then you can take a defense that whatever the amount you have taken from him, we have already refunded those amounts to him. Then you have to prove in your leave to defend that yes, I am not liable to pay a single penny to the plaintiff. And once you are able to prove it, then certainly your leave to defend will be granted conditionally or unconditional. So this is the application, and in the application in view of the above, it is most humbly prayed that this honorable court may kindly be pleased to grant leave to defend number 1 to defend the present suit on merits in the interest of the justice. This has to be your prayer class. So therefore, this is all about the leave to defend. If it is clear to all my learned friends, type out in chat box yes. Thank you. Now you will discuss certain judgments, how the leave to defend is granted and leave to defend is not granted, then what will happen. So first of all, we will say the judgments of the honorable court. In this judgment, the honorable court pleased to pass an order to grant leave to defend, but it has to be granted with condition. This is the Highline Apparels versus Suma Shankar Sharma and other. This is the commercial court suit recently, and this is all about the facts and circumstances of the case. This is all about the elaborate, but you will only have what happened in this matter. So I will come on that only issue, that what happened. I am only showing the judgment only because of that. You can imagine each type of the suit and what can order by the past. It may be conditional and unconditional. After considering the above facts and circumstances of the case, the defendant is granted conditional leave to defend. This is the conditional leave to defend has been granted under Order 37 CPC, as there may exist plausible or reasonable defense available to him, and some tribal issue may be there. we have to prove to the court, yes, there are the certain tribal issues. Once there are the tribal issues, then and only then the court will allow you conditional leave to defend. Plausible reasonable defense available to him, and some tribal issues may be there. Defendant can be given an opportunity to prove his defense in respect of the alleged fake bills. Accordingly, leave to defend application is hereby allowed, subject to condition to deposit the suit amount of rupees 6 lakh so and so in the shape of the FDR in the name of the court, which amount will not be given to the plaintiff till the disposal of the suit. Suit is now treated as an ordinary civil suit. Let defendant to file a written statement on the next date of hearing and also deposit the FDR amount as directed above. It means it is granted on conditional leave to defend has been granted, and the court has passed an order that you have to deposit certain amount, 6 lakh so and so in the form of the FDR, and you have granted leave to defend, and you can file the written statement. Then it is converted into the normal. And once this condition has been imposed and you have not complied this condition, then again the suit will be decreed against the defendant and in favor of the plaintiff. And once this order has been passed, this order has to be complied. Once it is not complied, then the decree will be passed against the defendant. Another order will look into whether unconditional leave to defend has been granted. This is the case. In the court of so and so, ADJ District Judge, South Delhi, Dwarka. And this is the case in which unconditional leave to defend has been granted. I will show the judgment. In the light of the above discussions and observations, prior defendant number 2's application seeking leave to defend is found to be raising a fair and reasonable defense. Although plaintiff is not entitled to a signed judgment and prior defendant number 2 is held to be entitled to unconditional leave to defend the suit, the application seeking leave to defend Order 37, Rule 35 CPC, moved by prior defendant is allowed in the above terms. In this judgment, unconditional leave to defend has been granted, and now he or she can file the WS within 30 days without depositing a single penny. This court further observes that the suit shall be tried unfluenced by any observations made in the present case, which is prima facie view of the further disposal of defendant number 2 application seeking leave to defend the suit. Defendant number 2 filed a written statement within a prescribed period from today, with the advance copy to be served upon the learned counsel for the plaintiff against written acknowledgement. Let application be filed plaintiff to the written statement of the defendant within 3 weeks thereafter, with an advance copy to be served upon the learned counsel for the defendant against the written acknowledgement. Once your suit is allowed unconditionally, leave to defend is allowed unconditionally, then you can file a written statement. Thereafter, the suit converted into the normal recovery suit. So this is all about the Order 37 CPC. I have discussed the theoretical portions and the practical portions as well, and I have tried to cover each and every portions of the Order 37. Once you have granted leave to defend, and once you have not granted leave to defend, once you have granted leave to defend, then the Order 37 suit converted into the normal recovery proceeding. And in normal recovery proceeding, you have to file WS within 30 days. Thereafter, the replications has to be filed. Thereafter, the issue has to be framed. And thereafter, both party will lead their evidence. Then the examination and cross-examinations of both the parties. Then it will be decided finally, and written arguments has to be filed, and final judgments may be given by the Honorable Court. So, dear friends, probably I am able to communicate properly and also try to updates about all those provisions of the Order 37 CPC. Even though if any friends have any doubts, have any query, please come forward, and whatever I have the knowledge, certainly I will try to answer that. Please. Anyone?
Sir, Shiv Tyagi this side.
Yes, sir, please.
हाँ सर, एक्चुअली एक कंपनी का रजिस्टर्ड ऑफिस दिल्ली में है,
जी जी
उसका वर्किंग ऑफिस नोएडा में है एंड साइट गाजियाबाद में है।
ठीक है।
तो वैसे तो कुछ एक्टिविटी नोएडा में हुई है, रजिस्टर्ड ऑफिस दिल्ली में है, और
जी
जो आरओसी लेटर वगैरह जाते हैं वो दिल्ली में ही जाते हैं, एंड जो कुछ एक्टिविटी कंज्यूमर के साथ होती है गाजियाबाद में।
जी जी जी।
तो इसका मतलब ये है कि जो जुरिडिक्शन है वो तीनों जगह बनती है, नोएडा में भी बनती है, मतलब गौतम बुद्ध नगर में भी बनती है, और गाजियाबाद में भी बनती है, और दिल्ली में भी बनती है।
अब
कॉज ऑफ एक्शन।
ये आपको देखना पड़ेगा कि कॉज ऑफ एक्शन जो है कहाँ कहाँ बन सकता है, क्योंकि तीन मैंने कॉज ऑफ एक्शन बताया आपको। एक तो कॉज ऑफ एक्शन अराइजेज अगर कोई एग्रीमेंट दोनों पार्टीज के बीच में हो रखा है, वो देख लीजिए कि एग्रीमेंट कहाँ हो रखा है, जिसमें एग्रीमेंट में लिखा गया होगा कि आपको इतने अमाउंट मैं आपको दूंगा, मतलब कंफर्म डेट है।
यस।
तब तो वो जो है जहाँ पे कॉज ऑफ एक्शन अराइज हुआ, जहाँ पे एग्रीमेंट साइन हुआ, वहां कर दीजिए। या फिर डिपेंडेंट रिजाइड्स आर कैरी ऑन देयर बिजनेस,
ओके,
तो उसका रजिस्टर्ड ऑफिस अगर जहाँ पे भी है वहां पे भी आप कर सकते हैं।
कर सकते हैं। तो इफ
बिल्कुल कर
इन
सकते
फर्दरेंस ऑफ दिस मैं ये पूछना चाहता हूँ सर, सपोज द गौतम बुद्ध नगर कोर्ट
हैं।
डिक्रीड द अमाउंट,
हम्म।
और उसकी रिकवरी के लिए मैं, क्योंकि रजिस्टर्ड ऑफिस कंपनी का दिल्ली में भी है, तो
हम्म।
मैं क्या उसकी रिकवरी के लिए, एग्जीक्यूशन के लिए दिल्ली में डाल सकता हूँ, दिल्ली कोर्ट्स में?
ना, क्योंकि जो जो कोर्ट आपको जो है ऑर्डर पास की है, आप एग्जीक्यूशन भी वही करेगी।
ओके, दैट नहीं, एग्जीक्यूशन जैसे मैंने कंज्यूमर कोर्ट का पूछा था, ये कंज्यूमर कोर्ट का ऑर्डर हम सिविल कोर्ट के थ्रू एग्जीक्यूट करा सकते हैं नहीं? तो अगर
वो तो कंज्यूमर कोर्ट का है, कंज्यूमर कोर्ट तो ये तो कंज्यूमर कोर्ट भी कर सकते हैं, लेकिन आपके पास ऑर्डर है तो आप ऑर्डर का एग्जीक्यूशन भी करा सकते हैं, लेकिन
सिविल
जुडिक्शन
के थ्रू,
देखना पड़ सिविल के थ्रू भी।
हाँ, तो
लेकिन
सिविल में दिल्ली में डाल सकता हूँ, सिविल के थ्रू होगा एग्जीक्यूशन उसका।
लेकिन अगर जहां से कोर्ट ने डिसाइड किया है ना,
हम्म,
उस कोर्ट की ही जुडिक्शन में आपको डालना पड़ेगा। अगर वहां पे
उसकी,
ऑर्डर 37 भी डालते हैं तो आपको उसी कोर्ट की जुडिक्शन में जाना पड़ेगा।
ओके, नाउ इट क्लियर।
जी जी
थैंक
जी।
यू सर, सो नाइस, आपका बहुत अच्छा सेशन रहा, एंड यू हैव given the practical approach is supported by the good judgments. Thank you very much, so nice.
थैंक यू
सर
माय
सर
प्लेजर।
शिव त्यागी जी ने एक क्वेश्चन पूछा था, वेदर वी कैन फाइल ऑर्डर 37 सूट ऑन द बेसिस ऑफ कंज्यूमर कोर्ट डिक्री। उस पे मेरी क्वेरी है
जी
कि would it not be amount to re-adjudication of matter, because once in consumer court, once the trial has been done, evidence is led and decree is passed.
जी
Once there is a decree, you cannot go and file a suit for the basis of the same decree, because there would be two problem, the practical approach and the theoretical as well, because I think there would be amount to re-adjudication of matter first, and then res judicata would come into play. The other thing is if
रेस्ट
practical
रेस्ट
approach,
रेस्ट ड्यूटी वहां होता है जहाँ पे पैरेलल आप टू सूट्स जो है एक ही सब्जेक्ट मैटर पे डालते हैं।
exactly, that I understand that matter in issue has been decided in the previous suit, but the debt has been decided. If
हाँ
I have decree of refund through consumer court, that means the date has already been decided that I am
जी जी।
entitled for the whatever the payment I have made.
Yes, yes. There is a already amount, whatever the court has been decided
Exactly.
that
So
this amount I will recover.
is there any judgment to that effect that you can file a summary suit on the basis of a decree passed by consumer court?
Certainly we will look into and certainly update you. आपको जरूर बताएंगे।
Because this is very new thing actually, because this has come into my mind while the session was
क्योंकि
going
इसमें
on.
इसमें पहले देखिए, जैसे पहले वाइंडिंग अप प्रोसीजर भी कंपनी के अगेंस्ट चलती थी ना, तो वाइंडिंग
Right.
अप अगर कहीं कोर्ट की डिग्री आपके पास है तो वाइंडिंग अप प्रोसीजर में भी आप जा सकते हैं।
No, that I understand. You can file a claim on the basis of the decree. Whatever the court has been passed, like RERA, suit, or whatever court, whichever court has passed the decree, you can file your claim. You can claim from the company on the basis of that decree. But
जी जी।
can you file a fresh suit on the basis of decree? That is my query actually.
चलिए जरूर इसको हम आपको जरूर बताएंगे जरूर।
That would be great, sir. क्योंकि मेरे लिए भी बहुत नई चीज है ये, क्योंकि अगर एक बार जैसे प्रैक्टिकल अप्रोच है,
यस 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 बिल्कुल बिल्कुल। क्योंकि जो ऑर्डर 37 यही कह रहा है कि अगर कोर्ट की कोई डिग्री भी होती है तो भी उसके अगेंस्ट आप जा सकते हैं, क्योंकि दिस इज कंफर्म डेट।
नहीं, कंफर्म डेट आई अंडरस्टैंड, बट
हाँ।
आई थिंक प्रोसीजर में डिग्री के रिगार्डिंग कोई जिक्र नहीं है, बट आई कुड नॉट फाइंड एनी जजमेंट टू दैट इफेक्ट व्हाइल सेशन वाज गोइंग एट दिस।
हम आपको उसके बारे में अपना
आई विल आल्सो लुक इनटू इट।
यस
अगर
रिसर्च करवा के आपको
ऐसा होता है।
इसके लिए प्रोवाइड करा।
सर एक रिक्वेस्ट और है, जो भी
हाँ,
सेशन
please.
का वो पीडीएफ फॉर्मेट वो पीपीटी था, कुड यू प्लीज सेंड मी ऑन ईमेल?
यस
That
सर,
would be
सर्टेनली
helpful. Thank you sir.
जितने भी
Session was very
जितने भी हमारे साथी हैं सभी लोग जो है अपना ईमेल आईडी दे दें, तो certainly we will try to share to each and everyone, and apart from that you also share the certificates for this program today, so then we will also share the certificates through email as well. पिछली बार भी जो सेशन हुआ था उसमें भी कई साथियों ने हमारे वो ड्रॉप नहीं किया था ईमेल, जिससे जो हम उनको जो है अपने सर्टिफिकेट शेयर नहीं कर पाए। Certainly please request to all of you, please share your email IDs in the chat box.
please.
जी जी,
Thank you so much.
थैंक यू
सर
जी जी प्लीज।
सर क्या हम समरी सूट क्रिमिनल में भी कर सकते हैं भाई?
क्रिमिनल तो कोई रिकवरी होती नहीं ना जी, क्रिमिनल में तो कोई रिकवरी ही नहीं होती है। रिकवरी थ्रू सिविल कोर्ट्स ही हो सकती है, क्रिमिनल में कोई रिकवरी नहीं होती। क्रिमिनल में कोई केस जो है केवल उनको पनिशमेंट मिलता है, रिकवरी नहीं होती क्रिमिनल में कोई।
ओके
प्लीज एनी ऑफ आवर फ्रेंड्स।
Good afternoon, sir. Sir, I have a question.
यस सर प्लीज।
Sir, I wanted to know, when we want to file a summary suit, what is the pecuniary jurisdiction of different courts to entertain a summary suit?
Especially once you are talks about the Delhi, apart from the Delhi, state-wise, it is there is no pecuniary jurisdictions for the lower court.
Okay,
But
sir.
once you are talks about the Delhi, then it is a pecuniary jurisdictions up to 3 lakhs. It is for the civil judge. More than 3 lakhs up to 2 crores, it's for the ADJ or district judge, and more than 2 crores, it go to the High Court.
Okay, sir. Thank you
Once
so
amount
much, sir.
involved is more than 2 crores, then it go to the High Court.
Okay, sir.
Original
Thank you,
jurisdiction.
sir.
And
Okay,
apart
sir.
from Delhi, another states, there is no like as a every civil courts have the original jurisdictions.
Okay, sir. Okay, thank you, sir.
सक्सेना जी, आप भी कुछ कहना चाहेंगे? आपकी आवाज नहीं आ रही है।
हेलो
यस सर प्लीज।
सर सॉरी
जी।
सर, मैंने एक्चुअली लगाया नहीं था तार, मुझे लगा कि शायद लैपटॉप से चला। सर एक इम्पॉर्टेंट पॉइंट पे थोड़ा सा डिस्कस ये करना था। आपने बहुत इंफॉर्मेशन बहुत अच्छी अच्छी देते हैं, खासतौर से प्रोसीडिंग से रिलेटेड होती है। प्रोसीडिंग कंप्लीट होने के बाद जो ऑर्डर आता है उसके बाद अक्सर प्रॉब्लम होती है एग्जीक्यूशन की। अब कुछ ऑर्डर्स जो कंप्लायंस नहीं होते प्रॉपरली, उन पे कंटेम्प्ट ऑफ कोर्ट की।
अच्छा,
मतलब कि दो तीन चीजें हैं सर। ये मतलब जब प्रोसीडिंग तो अपनी जगह पे सही है, प्रोसीडिंग हमने कर भी लिया, एक टाइम लगा भी लिया,
जी जी
उसके बाद अगर कंप्लीट नहीं हो तो हम एग्जीक्यूशन में जाएंगे या कंटेम्प्ट ऑफ कोर्ट में, क्योंकि अपोजिशन पे जिससे हमें अपना रिकवरी करना या लेना है रिलीफ, उससे हम कैसे लें, ये भी बड़ा कि इम्पोर्टेंट एक जो है पॉइंट
चलिए
है।
एक बार एग्जीक्यूशन पे सेशन लेते हैं।
ये सर मैं अभी इसको जो है ना, मैं व्हाट्सएप ग्रुप में भी इस चीज को मैं करने वाला था। हम लोग के इत्तेफाक से आप यहीं पे थे, हमने कहा सर आपसे डायरेक्ट बात करते हैं। अभी
जी, जी।
जैसे शिव त्यागी जी ने भी इस चीज को उठाया कि हम ऑर्डर उतना लेने के बाद भी हम फर्दर हम उस चीज को रिलीफ करने के लिए कैसे जाए। इट इज वेरी इंपॉर्टेंट।
ठीक है एग्जीक्यूशन पे ही एक सेशन लेते हैं।
सर एक इम्पॉर्टेंट टॉपिक और भी है, जस्ट थोड़ा अटेंशन पे कीजिएगा, लेटर ऑफ एडमिनिस्ट्रेशन पे।
जी जी जी।
जिनमें खासतौर जिनके विल वगैरह नहीं लिखी होती हैं, उनके अब जो डिस्प्यूट आते हैं, तो हाउ टू हैंडल, और ये कहाँ पे किया जा सकता है, किस तरह से?
तो एक बार हमने इस पे बिल पे तो सेशन लिया था कंप्लीट, लेटर ऑफ एडमिनिस्ट्रेशन को भी हमने डिस्कस किया था, बिल को भी डिस्कस किया था।
जी जी
लेटर ऑफ एडमिनिस्ट्रेशन इमूवेबल प्रॉपर्टी के केसेस में मिलते हैं।
यस 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 यस, बिल्कुल 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 याद आया।
और उसका जो है, जो हमारे मूवेबल जैसे कैश उसका रहता है,
हाँ
तो
हाँ
उसके लिए जो है हम सक्सेशन सर्टिफिकेट के लिए जाते हैं।
बिल्कुल बिल्कुल। अब अभी अभी सर आपने एक ऑर्डर शेयर किया था जिसमें कोर्ट ने ऑर्डर किया था जो अमाउंट है उसको कोर्ट में जमा करने के लिए।
जी जी।
मैं उस ऑर्डर को देखा, थोड़ी हंसी भी आ रही थी। अभी एनसीडीआरसी में एक कहानी हुई, 8 लाख रुपए ज्यादा बिल्डर को दे दिया गया। मैं उनसे रिक्वेस्ट करता रहा कि सर ये डिस्प्यूटेड अमाउंट है, इस कोर्ट में जमा होना चाहिए। मैं डिस्ट्रिक्ट लेवल पे देख रहा हूँ कि अमाउंट डिस्प्यूटेड है तो कोर्ट में जमा हो रहा है, और हाई कोर्ट के जज वहां बैठे हुए हैं, वो कह रहे हैं बिल्डर को दे दो, ये बिल्डर है, जाएगा कहाँ?
उसको आप चैलेंज कीजिए।
नहीं सर, चैलेंज हो नहीं सकता सर। बहुत कुछ चीजें हैं ऐसी जो एनसीडीआरसी पे कभी बैठेंगे सर, तब डिटेल में आपको शेयर करेंगे।
जी जी
ठीक है?
प्लीज।
अभी जैसे 2 पॉइंट के लिए, एक एग्जीक्यूशन का मैटर और एक कंटेम्प्ट ऑफ कोर्ट, ये 2 चीजें हैं, ताकि हमारे ऑर्डर का आखिर में किसी तरह से कंप्लीट तो हो सके। वरना लोग मोस्टली क्या है ना, ऑर्डर लिए हुए होते हैं, आते हैं, उन्हें फर्दर पता नहीं चलता है अब हम क्या करें अगर सामने वाला उसको फुलफिल नहीं कर रहा, कंप्लायंस नहीं कर रहा है।
ठीक है, चलिए आपने बोले तो नेक्स्ट सेशन जो है।
श्योर श्योर, थैंक यू सर, थैंक यू,
थैंक यू, थैंक यू,
नाइस टॉकिंग टू यू सर।
थैंक यू मोस्ट वेलकम। एनीवन ऑफ यू? Yes, Ms. Yasika, please. We thanks to all of you for learner friends who have joined and give your valuable time. Certainly, I take 1 hour. That is very most important time to all of you. And certainly, we try to convince and try to update the knowledge. Therefore,
Sure, sir. So
yes,
I
sir,
stand
please.
hereby today as proud and grateful to express my heartfelt thanks to all those who made this session possible. And I would like to start by thanking Vijay Vidya Foundation, who have always been supportive and encourage us to strive for excellence. I would also like to extend my gratitude to you, Dr. Nityanand Singh, who have been our guiding light, imparting wisdom, knowledge to us and nurturing our talents. Their unwavering support has been instrumental in our growth and development. I would like to express my appreciation to all our guests who have taken time out of their busy schedules to grace this occasion with their presence. Your presence has added the extra spark to the session and made it even more special. So thanks again to all of you.
You are muted, sir. You are muted, sir. Sir, kindly unmute yourself, please.
Yes, yes, sorry. We used to take the session on second and fourth Saturday, every second and fourth Saturday in the month, 2 times in a month. And whoever wants to join, you are most welcome. Certainly, I try to share the knowledgeable things through this platform, Vidya Vijay Foundations. And certainly, if any one of our learner friends wants to share something through this platform, they are also most welcome. Thank you. Thank you to all of you for your very valuable time of 1 hour. Thanks. Certainly, we'll meet on the second Saturday. Thank you. Namaskar.
Thank you, sir.